Hey, hey.
Podcast number 6.
Happy Friday.
Happy Friday. I think we're learning something new every time, right? It's getting a little bit better.
That's the eternal progress and process that we're in, right?
I hope the sound is coming through good. Everything seems to be checking here. Um, but let's go ahead and get started. A number of things happened since the last time we talked. Seems like 7 days is too much time between podcasts. There's so much information going on, and so much change.
Yeah, it is. I was thinking about it as I walked back in here to get ready. And I was thinking, man, we have to open with both like a recap of last week as well as kind of tease things out over the next couple weeks. Obviously, the recap has some pretty good substance. And then just looking forward to the next few weeks. And again, to tease it out for everyone out there listening, you know, our House Bill 1240 case. We should have a motion filed in that in the next couple weeks. We're going to have an update on obviously a hearing in the Turner versus Washington Medical Commission case, which is challenging the Washington Medical Commission's COVID-19 misinformation position statement under the Administrative Procedures Act. And, those are just two of the first things that come to mind that we have coming up over the next couple weeks. So, this is one of the ways we do keep everybody updated. I think that's important to know. We do send out our Substack. Again, we've got an awesome social media team that's staying on top of that. We send out our emails as well, but this is hopefully a little bit more of a in-depth and semi-engaging way to get people to know what we're doing, uh, especially those who are donating and praying on our behalves to really know what it is that we're doing with those resources they provide us. So, anyway, I know that's an interesting introduction, but I think it's important that people get where we're coming from on this.
For sure. For sure. So we kind of try and plan out what we want to talk about. We know it's going to be bouncing off each other and playing on a little bit, but I think one of the things top of mind is something that's happening locally or happened locally, um, which if a little background, anybody that doesn't know our Genesis story, one of the first things Pete and I did together in this fight against tyranny in Washington State is actually go to Olympia and file papers in a recall effort of Jay Inslee. And I mentioned that because it's a recall effort, and if anybody who has ever been taken part in a recall effort in Washington State, they understand just how difficult the process is and what it really takes to get through the entire process. And we actually had, is this the second recall now in Benton County?
Yeah, at least in the past 4, maybe 5 years, maybe even 3 years. So, there may be some that are predate us, but in the past less than 5 years, this is the second recall, and this one involves 3 people. So it's not now obviously it was lumped together, but it is a second successful recall effort of an individual or individuals in Benton County.
So let's talk a little bit about that process, just a little bit, because the point we're trying to make is how difficult it is, and what we ultimately see was the cause of the recall being successful. What can you go step by step what a recall takes in Washington?
Yeah, so to get recall, the first thing you have to do is you have to get the petition ready, meaning that you have to have some sort of charges, and that those charges will be submitted to, if it's a state officer, to the Secretary of State, who will look at the charges, and there's no opinion on whether there's merit to them. It's just like, okay, this adequately provides the information. Like, I'm recalling Pete Serrano because he embezzled money from the city of Pasco as a city councilman, right? To be clear, that's never happened. But, someone drums up those charges to me, or he yelled at my dog when it peed on my lawn or his lawn, right?
Right.
So the Secretary of State will look at that, and then the Secretary of State will shift that over to the Attorney General. And the equivalent for the local is the auditor of the county and the prosecuting attorney of the county. So in this case, the Benton County Auditor, Benton County Prosecuting Attorney. The prosecuting attorney has the duty, or again, the Attorney General's office has the duty to write up the ballot synopsis and then you still have to litigate that potential. There's a potential litigation over that. We've been involved with that. You have, I think it's a 30-word title and then like a 150-word actual synopsis of the charges. So you go through that process, and then you still have to litigate the charges themselves. In this case, there were several allegations. I think there were 7, and I think 4 or 5 stuck with these members. One was that they had violated the Open Public Meetings Act by having a quorum meeting and discussing issues specifically to this recall effort in Benton County related to masking and taking masks off kids. The Chris Reichdahl, the OSPI, Office of
Superintendent of Public Information.
Yeah, public instruction. OSPI, Office of OSPI. Chris Reichdahl. So
we sued him.
Yeah,
that's
right.
all we know.
And so, in violation of OSPI and the governor's mandates. So there's the Open Public Meetings Act. There were some other of office. Our group would have to hang its hat on is not only was it wrong for these people to violate the Open Public Meetings Act, but it constituted an act of either misfeasance, malfeasance, or a violation of their actual oath of office. Now, without having to get into distinction between those three, really it's, did you knowingly or unknowingly do something that violated your oath, or any of whatever number of allegations you have sticks through the Superior Court. Then you move forward with the signature collection on that recall petition. And then if you have enough signatures that are gathered, it's, I believe, 20% of the most recent election. So if you hit that 20% threshold, then and again, I'm going off the top of my head. I should have probably put a little more time into research. Wanted to talk about it. But if you hit the threshold, then your next step will be to actually have the election. So the steps really fundamentally are: you drum up the charges, provide them to the proper elected official, you get your ballot synopsis. After your ballot synopsis, then you're going to move forward with collecting the litigation on the actual substantive charges. Then you collect signatures. If you hit the threshold of signatures, then it moves forward to the actual election process. And in this case, it appears, unless there's some ridiculous flood 4 days later of ballots, that these 3 individuals be recalled. So it's not an easy process. So the fact that it got as far as it did, quite frankly, looking at the charges blows my mind. I didn't think they had merit, but that's a personal opinion.
So let's talk a little bit about that. We, as weak as the charges were, as many hiccups as there were in the court to get to the point for the recall, what do you think ultimately caused the success to come? I mean, there were lots of roadblocks in the way for the recall, as you just outlined how many things you have to accomplish in order to get to a ballot. Then what happened with the ballot? What do you think? Why was this recall successful despite all of the hurdles it had to overcome?
Well, I mean, if we're only skipping to the ballot element of it, it's one simple word: it's apathy, right? I mean, I think last I saw it was tracking at like 26% voter turnout in Benton County. I mean, think about it this way: they had to collect 20% signatures of the prior election or prior election involving that position. So if you knew that you had to collect that threshold and you held on to that list as the individual or group making the recall effort, you theoretically could ensure that 20% of 20% of the voting population then just goes ahead and votes, right? 3, 4, 5 months later, once it's secured. Now, I can't say that the recall effort actually did that, because if 26% voted, then they didn't even pull that 20%, which also indicates there's a question of whether or not or how they inflated the signatures in the signature gathering process. But when it comes down to it, is the first week of August, the first Tuesday August, which was I think the first or second this year. If only 26% of the people in the whole county have a ballot, and even in a conservative county like Benton, you easily could have swayed that with a 100% turnout.
Right.
Well, when 1 in 4 people turn out this call on both sides, the question is who engaged better.
Yeah. Who was more upset?
Yeah, exactly.
Or who was louder, maybe?
Yeah, or who actually was willing to spend the 3 minutes to fill out a ballot and then walk it to the mailbox.
Right.
And that's a big part of the issues with politics in this state. I know people are like, oh, King County controls, and that may be partially true, but I think it's exactly that, partially true. Again, I mean, we've beat this drum, you and I together, and others that we are friends with. When you have conservative counties in a really important election like, say, 2020, where they're turning out 76 to 80%, that's still 20% of the group. And if that's like a 70%, conservative side, you're losing whatever that is, like 15% or 12% of an increase of that. And you aggregate that over, we have 39 counties, probably 34 counties are true red, maybe even more. And so if you aggregate it, that apathy really plays out very poorly on the side of the team that's apathetic.
Yeah, I remember. Was it the 2020 election? Josh Reed ran for governor.
You're really asking me.
It was
that sounds like it had to have been 2020.
Yeah, it was 2020, and you made that connection, and I think that was one of the first times I actually sat down in a room with a candidate for governor and was able to ask pointed questions. And I was coming from probably that apathetic, typical, citizen of Washington State, seeing everything turn blue and go bluer, over the course of my adulthood. And my first question to Josh Reed was, how are you going to overcome that Democratic vote in King County? And I don't remember the exact number, but when he laid out what you just said, but if you go county by county and look at it, it's only a few votes, relatively, per county that it's going to take to overcome that gap that King County supports. So I think you're right. I've been convinced over the last several elections that it is an apathy that we have to overcome. It's not policy or ideology even. It's an apathy of the voter in Washington State. And we were at Freedom Fest. Was it Freedom Fest that we call it? Summer Freedom Fest in Redmond. And looking around, what would you say the average age was of the group there?
It was a younger crowd than expected. We probably were in that middle because there were some younger and some older.
There were some younger and some older, but if you took the average of I mean, there was a good cross section. I'm not going to deny that. But you took the average of the age there. There was a lot more gray hair in the crowd than there were young kids bopping around or even young families there. And I think I looked over at you at one point and said, "How do we activate our generation? What is it that we're going to do to get them? What's going to finally spill over into activism, into just as small as getting educated to vote, not just to vote. There's a lot of people that don't even take the time. They'll vote, but they don't take the time to educate themselves, and they're just voting D or R or whatever it is on the ballot that convinces them to fill in the blank. What is it? What do you think that spilling point is going to be?"
That's a great question. I think we even had a conversation with our friend Josh this morning, that not Josh Freed, a different Josh, that was very on point of that. It was, what are the men of our generation doing to combat their kids? You and I have pulled our kids out of school, right? Because we don't go with the indoctrination.
Well, we're schooling them. We didn't pull them out completely, or we are. I'm homeschooling, and you're doing a private school.
Right.
We pulled them out of the public
school.
institution, the public schools.
And so removing removing the obstacles is part of the solution, but that's not the solution. You know, it just means that other people's kids suffer. That's exactly where we nailed that, right? When we were talking today is, okay, and so now you and I have started a foundation, and Vince, and back when Eric was in, we got this foundation rolling, and we're doing great work. That's still part of the solution. I don't know. I don't know. I mean, it took me a while to wake up too, right?
Yeah.
And everyone has to have either their moment of crisis, their moment of faith, or whatever that awakening is. And I just, if it hasn't happened yet, I don't know what to do.
Right.
You know, I mean, I've talked to you a lot about this. Like, I'm getting ready for the next pandemic because I know whether it's been intentional, unintentional. Biden's made comments about the next one and being prepared for it. And I don't, you know, whatever that means, right? I think, quite frankly, the government did everything it could to push us as far as it could to see where our threshold is.
Right.
And if you're not awake to that yet, I don't know what will wake you up. And I don't know how far your civil rights have to get infringed and just smashed and trashed and trampled on to care.
Right.
And, you know, specifically forefathers. You know, I don't want to talk about parents. I want to talk about fathers. Men, you have an absolute duty to your wife and to your children. And if you have neither, to your neighbors, to stand up and be something and do something. You can't just cower and say it's scary, it's hard. Yeah, it is. It's absolutely devastating, some of the losses we take. But we come back and we fight. And we don't fight. We've provided solutions for our families. We're fighting for your kids.
Right.
And if you don't get that, like, wake up. And if I can't wake you up, then you're probably not listening to the podcast.
Well, Pete, I'm going to play devil's advocate here and say, you know what, I'm a father. I've got, you know, 4 or 5, I've got 6 kids, but 4 or 5 kids at home. I work 60, 70 hours, breaking my back every day to just be able to stay afloat, especially in this economy where the gas prices are just choking me out. The groceries are just killing me. What am I supposed to do? How am I'm barely able to get by. How am I supposed to fight this? What am I supposed to do?
I mean, you have several options. One is actually engage yourself, right? Go to your school board meetings. And I get it. You know, people get frustrated. I would go to the school board. They don't listen. I've served them with notice of whatever, and that was legally insufficient, so it didn't work, right? I get it. But I think it's not just, you can't just go with the one offer. We've always talked about this. You go in 1, 2, 3 Z's, maybe even. It's hard to beat the system. You get picked off. I can tell you this, as a sitting city council member, there are times when I go into a meeting. Now, it's not always effective, but there are times when I go into a meeting and I know it's going to be a hot topic issue. I walk in, I drive up, I see the parking lot, I see how full it is, and I am preparing, and I might tweak my preparations, right? And I've seen that type of engagement from a larger community be successful. Now, I'm sure anyone that could call me out and say, well, what about the pot shops in Pasco? Why weren't we there? I'll tell you this. The way the council saw it was a 50-50 draw. Now, you and I know that wasn't true.
Right.
But if you look at the engagement numbers, it was.
Yeah. Yeah.
So why weren't, I'm not going to say you, but I'm going to say generally, if that's your hot button issue and you weren't in Pasco down at City Hall, why weren't you there? You know, if you're mad about school board, you've worked in 60 hours, you can't send your kids off to homeschool or a private school. I mean, to be clear, I'm not sitting on this high hog life. It's a tremendous financial sacrifice for me to put my kids where I put them.
Well, you're double paying for it.
Yeah, I'm paying in my taxes, and then I'm paying another hefty penny to put them there. But that's what my wife and I decided we would do to protect our kids. So there are things we're missing out on, vacations we don't take, other luxuries we don't have that, you know, some folks might say, oh, well, why don't we have that? Because we chose to protect our kids. So back to the question. even if you have very limited resources, and I'm talking not just financial, I'm talking about time, organize yourselves. You know, you've got coworkers, you've got neighbors, and come down. I'm not saying like literally with the pitchforks, but come down with the pitchfork mentality and say we're done. And then if you're not voting in the elections because you're mad about it, because the city council member or the school board didn't listen to you, you're still part of the problem.
Right.
You can't force someone to take your side. But what you can do is, well, we talked about 2 successful recalls recently in Benton County. Recall is an option. Engage in that process. The alternative is vote them out. And if you're not engaging in either, then maybe there are your solutions right there.
Well, let's talk about that beyond the vote, beyond the recall, beyond the actual action. How many conversations do you hear? I mean, you and I guess, are going to be a little different because people know that we are actively involved in this type of work, or this. We feel and know that we've been called by God to make a difference and to protect our families in this way. How many conversations do you think are being had around the dinner table, at gatherings, parties, that actually have any real substance to them politically?
Probably not a ton. You know, I mean, what are the 2 rules? You go to family dinner for Thanksgiving or Christmas, and there's no fly zones, right? No politics, no religion.
Right.
And if you're not willing to break that, especially with people who you're supposed to be most comfortable with, especially in a position of discomfort, right? I know we disagree, but we have to look. I've got family members that we disagree, but I still talk about it. I'm not rude. I'm not going to hide what we're doing. Yeah. You know, I got my wife's family happened to be in the school district of Sandy Hook, and we're fighting to make sure there are greater than 10 round magazines carried by you and I.
Right.
You think that's an easy conversation to have? No, not at all. These people were directly, personally impacted by someone who was crazy that used these firearms, these protected measures, in our opinion, in a very bad way. But, you know, we also don't talk to people about, like, what happened to the kid that gets run over by some jackass speeding. Is that Toyota's fault? No.
Right.
So, I mean, there's a level of discomfort that has to happen.
Yeah, I agree. I think there's definitely some discomfort, and there's some uncomfortable conversations. I mean, around my family dinner table, for the most part, is, you know, there's conservative feelings, but there are those that have different opinions, right? That, you know, we're going to have different opinions. But in my experience, the fear was greater than, you know, the actual confrontation, right? It isn't difficult once you've broached the topic to have those conversations and to have them in a peaceful way. They don't have to be confrontational. They don't have to be, I'm right, you're wrong. There can be a spirit of peace, or of, hey, you know, this is my opinion, this is my experience, this is how I feel, and what I think can fix it. Right? There's a problem here. We both, for the most part, we all agree there's a problem.
Right.
There definitely is a problem. How do we fix it? We disagree on what the solution is. It's interesting that that's really what divides us, is not the problem, it's the solution.
Yeah, I mean, and like I said, I mean, going back to those conversations, we still love one another. We, you know, and to your point, I think we agree on more than we disagree on. There are just some points that you've got to understand that you're going to disagree on them, but you move forward in a spirit of love. And I mean, we've got a great relationship with those family members, and, you know, and everyone's got something they have to overcome, you know, in conversation with others, whether that's a family member, a friend, where you're going to disagree, whether, again, it's a social issue, a political issue, a religious issue, and you just move forward from a piece of care and concern and love. And, you know, maybe it does become kind of okay, this one's going to go nowhere. It's going to devolve into an argument. We'll stop here. But at least you've been willing to open the topic. And at some point, there's an opportunity for conversation. I don't think I would have had these conversations a decade ago or 5 years ago. But I mean, obviously, with us so engaged in this particular issue, it naturally comes up, and it was an there are the right opportunities, I guess I'll say.
Right. I think that leads us nicely into another topic that we wanted to discuss. One of our friends, Jim Walsh, Representative Jim Walsh, made a Facebook post today. He shared a post from somebody else where what looked like to be, and can't confirm because there's a picture, looked like to be a homeless drug addict in the middle of a crosswalk that losing their shoe, losing their pants, passed out, with passersby completely ignoring them. And yeah, from a Christian perspective, the Good Samaritan comes to mind, right? How can you pass by somebody that's in obvious distress, just completely obvious distress? And Jim's point in that aspect was this is a social problem that needs to be addressed at many levels, not just at some levels or at a legislative level, but many levels. What were kind of some of the things that came to your mind when you saw that picture and I showed that to you?
Yeah, I mean, I struggle to not say I'd probably be one of those passerbys that it's easier to not look. I would hope that I would at least have some humanity to check on the person, and some of the thread. I don't even think it was the comments. It was actually in what he had posted. There's always the concern that this person's going to wake up, or if you wake them out of especially a drug-induced slumber-like state, are they going to be violent? I get that. You have your kids, you don't want to risk that. But yeah, I mean, it's a problem we've created ourselves.
Right.
I mean, the politicians own this.
I agree. Well, let's dive into that a little bit. That post led us to a conversation about a lawsuit that happened a couple years ago.
Yeah,
that's commonly known as the Blake decision. It went through this cycle in the legislature. They didn't fix it. They had to call a special session just to fix it. Pasco, I believe, picked up a special, whatever you call it, in the city just to address the drug problem in Pasco. What do you think that in the Blake decision? There's so many levels to it, and we've discussed this over the course of the day. But let's kind of just peel it back a little bit. What are your thoughts about what happened there?
Yeah. So let me fast forward to it wasn't a fix. Shocking ending here. This special legislative session, which lasted all of, I think, 12 hours, if that, one day, less than one full working day. It might have been 2 days, so maybe I'm wrong here. So,
well, anyway, we'll count how much their butts were actually in seats.
Right. Oh man, yeah, very little time, and it was a foregone conclusion that they could only walk back the quote unquote fix so far. So for anyone that's not heard of the Blake decision, it's State of Washington versus Stephanie Blake, I believe was her name. Shannon Blake. My bad. So this happened. I believe the case came out in 2021, and so the events were, I think, in 16 and 19. What happens is Miss Blake, the Spokane Police Department, is going out searching for evidence of stolen vehicles. They arrest some people, including Miss Blake. Miss Blake happens to be, by the story or not, this is what's written, and I wasn't there, so I don't know. She's, quote unquote, borrowing a pair of pants, and as you all know, there's the coin slot, at least in men's jeans, like that right pocket typically. It's that little tiny guy that's inside a pocket. And inside her coin pocket is a baggie of methamphetamine. She gets searched at the police station because she's arrested relating to these, vehicle thefts, which already gives me the indication that she's at least not running in the right company.
Right.
And then she's got meth in her pants, her quote unquote borrowed pants. So that also forecloses the idea that she's got great company.
Right. And
but
to the amount that I mean, there was a felony charge,
yeah,
correct?
it was a felony charge. So she gets, arrested, and she goes through the appeals process. So she's convicted, arrested, convicted, and goes to jail. And the question before the court, or the question that the court really seems to ask itself so it could opine on it, is whether or not there is an opportunity for what they call the mens rea, which is your mental capacity, but it's not just whether or not this mens rea component, the mental capacity. In other words, knowing versus unknowing possession, but they really fine it down to I want to get it right here. It's like active or passive conduct. So it's not only when the legislature prohibits the possession of drugs, right? There is no mental capacity there. It's just, do you have drugs on you or not? Okay, in Blake's instance, she's got meth in her pocket. Boom, you're done.
It's on her person.
Well, what they've done through the Blake decision in 2021, the state Supreme Court pulls it into this question of to whether or not there's a passive conduct that could be strict liability, meaning, do you have to actively know that you're possessing? And they really whittle it into this corner. It's hard to not believe that they weren't looking for their answer, right?
Right.
And because the legislature had it as a strict liability for years.
Mm-hmm.
So it was squarely whether or not you're possessing, boom, you've got it on you, you're done. You are a felon. About, whether or not it's interesting that they try to flip the coin too on the state, where it's like, well, the state didn't prove she knowingly possessed it. It's like, well, that's because the law back then wasn't that you had to knowingly possess it. You just need to possess it. I'm just trying to pull through. But the bottom line is, I will say this, and it really tipped my eye on, there's a strong discussion of due process, meaning was Miss Blake given the proper procedural opportunities to challenge this? And it's like, if the state Supreme Court's going to claim that their decision to overturn or open up legislation, even though they claim they didn't, they did. They reinterpreted it. That's not their job. They
Right.
try to claim that they're staying in their lane, but they're like, they're opening the question of passive knowing intent. I mean,
Right.
the legislature doesn't have those terms. So
Before we go a little further, I have a question for you. Did you know that we had invented time travel?
I did not.
Didn't know that?
No.
It's interesting because with this Blake fix, I'm finding out that because they made this decision, they were able to now go and vacate 200,000 convictions.
Oh, something.
So back
yeah.
back to 1970.
Yeah.
It's incredible to me that they were able to go back to 1970 and just wipe those convictions right out.
Yeah, and it's crazy because and I know I kind of got too nerdy on the law stuff. The bottom line is what Blake did is it makes it so that you have to knowingly possess and actively possess drugs to be convicted of a felony. And what kicked this conversation off between you and I was I got an article from the Washington courts send me stuff, updates every day. A decision in XYZ case or an op-ed on this. And today what I saw was state launches refund portal for legal fees from vacated drug cases. To your point, over the past 3 years, 200,000 drug convictions of either, I think, gross misdemeanors or felonies. You and I are now paying to not only vacate those, meaning from the state side, actually the legal process of
paperwork.
reprocessing it. So we're paying
Right.
someone to do that.
Right, and I'm in a law office. I'm not a lawyer, but I see the paperwork that's required for anything that has to be done with the law.
Yeah. And so we're paying for people to process that paperwork. But, guess what? If you happen to be one of the lucky ones that was convicted on those felonies, not only does that get wiped off your radar, now granted, you don't get your time out of jail back, right? Like
Right,
you
no.
can't, only we can time travel, the taxpayers can,
Yeah,
right?
Yeah.
But you and I, the taxpayer, are on the hook of refunding any costs in fighting this or any costs that were incurred of, like, hey, you had $1,000 fine, a $10,000 fine, like any costs associated with that. we, the taxpayer, are funding. It's ridiculous. I don't know any other law that's like, well, the Supreme Court decides that it's not really what it meant, and we're going to go ahead and refund people for 50 years. Again, they can't get the time out of prison,
Right.
but we're going to give them money. I mean, like, this is just absolute garbage.
Limits that changed, that got faster over the last 20 years that I got tickets on those roads, and now it's faster. So should I go back and get reimbursed for those tickets that they handed out?
Why not? Hey, say the Blake fix is pretty clear that you got a speed fix in Moses Lake. And when I was 16, that was 25. It's now 45. Because, mind you, they have obviously gone from 2 to 4 lanes and done a lot of traffic improvements, but that doesn't matter because the state decides you can have that money back.
No. And there's another aspect of this, which I think is as insidious as any of this is. We're talking about 200,000, possibly 200,000 felons that, as a felon, your voting rights are taken away from you, among other rights, but specifically your voting rights. Now that's a huge pool of people that essentially got their vote bought, as far as I'm concerned. Now we're going to vacate. Hey, you know what? You're a felon. We're going to vacate that felony. You're going to give you your voting rights back. Oh, and by the way, we're going to pay you for your vote. We're not paying for your vote. We're going to pay you back for those fees that were incurred. Wink, wink. Now, remember, it was the Democrats that voted for this.
Yeah, man. Frustrating is not the right word. There are a lot of words, certainly one that starts with F that I could say. That would be absolutely on point for this, but it's ridiculous that not only are these. So again, the law hasn't changed until 2021, and the law really didn't even change. It's the interpretation of the law,
right?
And they're going to go backwards, retroactively, say like this law as though it never existed. I don't understand it. I mean, laws change. At what point are we going to say, anyone convicted of jaywalking that paid a civil fine is going to have to get their money back? I mean, we're going to owe criminals money.
This is a Pandora's box. It's just not. How do you close it at this point?
The only way to close it is to say, hey, the Blake decision was wrong. The Blake fix didn't fix anything. And we're going to actually go back to criminalizing criminal activity. Oh, and by the way, we're not going to refund you. I mean, look, you and I were talking about this, pretending that OJ didn't do it. If the DNA evidence and the Bruno Maglies were stilettos and it was a woman's glove that had all that DNA evidence on it, and it was some other chick, some other side chick,
right.
that was mad at Nicole and Ronnie, that would be a different story. I understand when there's exculpatory evidence found guilty is innocent, but that's not what we're talking about. These people still were convicted of drug possession at the time, and now we're reinterpreting it after the fact and saying, oh, by the way, our bad. The law as it was written was always legal until 2021, but now we're changing how we see it, and we're going to wipe that off your record and give you money. That's ridiculous. I mean, there are lots of things in my life that I want that eraser for.
Right.
I don't have it.
Absolutely. Absolutely. Now, I want to bring this kind of full circle back to where we started this conversation. And there is a drug problem. And we understand there's such thing as addiction. And absolutely, have that empathy and charity in our hearts for those that are suffering from those things, for those that are homeless because of it, that are suffering mental issues or physical issues. Absolutely. We understand that the law, criminalizing any kind of drug use or possession, is intended as guardrails that we have as a society. But taking care of those people that have those addictions or have those problems, that's another level of society. That's a more personal or community issue that needs to be addressed. But it has to have those guardrails. We have to have the rule of law in order for us to have the framework to be able to then help those people. It's not okay that woman was laying in that crosswalk, clothes falling off, out of her mind, anything, any number of things that could have happened to her. And the way that it was described in that post was just dying a slow suicide in front of everybody in public. We have to, as a society, say that's not okay. We have to have a framework that fixes that, that addresses that, and that allows us as a community to not walk by that person and not say that's somebody else's problem.
Well, and one of our biggest issues is the so-called Blake fix prefers treatment, right? There's a diversion process where, as opposed to going to jail, you can divert out of jail, but it's optional.
Right.
At whose discretion? The users, not the police, not the cities, not the counties, not the people that have to take care of the individual, but it's the individual drug users that's been convicted of a violation of a statute or a local civil code, and it's their option. I don't know a ton, and there are few. There are some folks who are desperate to get help. Typically, they're not gonna only get it, as far as I can see, only after they're convicted. The problem is when you make that optional and you don't give an incentive for it, you can't mandate it. I mean, there was a great case. Well, not a great case. There's a recent case out of the state Supreme Court about involuntary holds. There's no question that forcing someone into treatment isn't an involuntary hold if they don't want it. So, yeah, I don't pretend to have that answer. I'm not a mental health counselor. I'm not any type of counselor. I'm a counsel, right? But there has to be something, and we can't just walk by it, and we can't decriminalize it into acceptance.
Right.
Both of those are the wrong solution because it becomes more pervasive.
I agree. Now you hit on a topic. I think that is a nice segue into our next line of thinking with medical freedom. You talked about not being able to, the government not being able to force treatment. I think that absolutely is key to why we even exist. We saw the writing on the wall with COVID and where that was headed. If there wasn't some checks put in place, especially here in Washington, I know a lot of people have forgotten it, but they were definitely headed towards camps at one point, medical camps, whatever you want to call them, for COVID patients, where they were going to involuntarily put people in there. Let's talk about medical freedom. Let's talk about where that current fight is. I know one of the doctors that we're representing has made some progress in his case.
Yeah, I mean, so we fight it on several fronts, right? You mentioned this one happens to be Dr. Lin. He practices here in Tri-Cities. Chinese immigrant sees COVID and is like, they're taking my right to treat people. And he's like, I fled communism because I don't want to relive this.
Right.
These are people, and he's not the only one who I've had the conversation with. It's like, we left our country and, pick a, European country or anywhere else.
Yeah, but just about anybody that has a foreign accent has a socialism or communism story that explains why they're here.
Absolutely. And they don't want to be there because it's not better. Right. And so, Dr. Lin gets hit for prescribing ivermectin. And of course, the state's not enforcing its COVID-19 misinformation position statement. It would never do that because it's coming through the Uniform Disciplinary Act. There's no question that they use this COVID position statement to get to discipline. I'd love to have them actually admit that. Of course, they won't because they know they'll get sued, which we're doing for the second time on this. So fighting on that front, we brought that Turner case in Benton County, and we'll have a hearing on it on the 15th. If that gets an injunction, that could really open up the door for all of these doctors to get some additional protections for what they did, mind you, 2 years ago.
Right.
So let's talk about Blake.
Okay.
And let's talk about that. These doctors should get, if we get an injunction under the Blake analysis and Blake refund BS, these doctors should get the 2 years of lives back that they fought. Ryan Cole should get his practice back.
Right.
That's not going to happen because, instead of using illicit, illegal drugs and being a victim of that, these people were providing medical treatment with a tyrannical government that limited those options. I mean, talk about a double standard. It's total garbage.
Right.
Um,
It's insane.
it's yeah, it's absolutely frustrating to look at it from that standpoint of here we have people whose convictions are overturned and they're getting money back. And when our clients, Dr. Lynn, we're working with Michael Turner and Dr. Turner as well. We've worked with Scott Miller and Dr. Wilkinson to preserve their licenses. When all is said and done, and the other dozens, at least dozens of doctors who've been hit for prescribing ivermectin to keep people from dying, they're going to walk away with hopefully their license intact and thousands of dollars and probably hundreds or thousands. Scott Miller's been 2 years, however many hours of countless sleepless nights worrying about that.
Right. What a juxtaposition to be able to have, where we're talking about people who are obviously living outside of the structure of society and the rule of law, and them getting some sort of benefit protection from the government or handout or whatever you want to call it, versus those that are obviously licensed because they're living within the structure of law, under the rule of law, following the directions and doing everything they can, yet because they have a principle or knowledge or understanding that's contrary to what the ruling medical commission currently has, they're being the ones that are under suspicion and being punished and having their licenses and their lives ruined. What a crazy backwards world we're living in that we're seeing daily.
Yeah, it's through the looking glass, right? I mean, and I wish it were better, and we're actually through the looking glass. We're stuck in this warped world. Again, I mean, I hate using the word tyranny. It was overplayed throughout the pandemic. Anything that people seem to disagree with, especially on the conservative side of the coin, it was, well, that's tyranny. And it's like, well, that's not tyranny. That's just a really bad governmental imposition on you, right?
It's a bad policy.
Yeah. But in this case, it certainly is. When you're the ruling class and you declare something that's illegal okay, and declare life-saving, prescribing ivermectin to keep people out of hospitals when they're going to kill you on a different protocol, then you should be the hero, but you're the GOAT, not the GOAT, not the
The
Michael
greatest.
Jordans or Tom Brady's. I know everyone loves him.
Isn't it interesting how the GOAT can be the best and the worst?
It is. And so anyway, yeah, it's crazy that we have this warped reality where heroes, I mean, that's why we protect these doctors. These are the heroes that said, no government, I'm not just going to send this person home. I mean, that was what drives me nuts about these medical freedom cases, at least when we're defending licenses. The options were, oh, hey, how about you get monoclonal antibodies?
Right.
Weren't available.
We're taken out of some states.
Yeah, they didn't exist in many of these patients' cases. And in some patients' cases, I'm going to run back to Wilkinson's case. Someone living in Yakima, you think you want to go to the hospital in Seattle mid-pandemic to get that?
Could you even get there? And what were they going to say when you got there?
I mean,
You're not sick enough.
And so the medical commission defers to this non-existent treatment. I mean, yeah, it was there, but it wasn't there. And it says your option was to send them home. Because some of these people, again, I'm going to defer to Wilkinson's case. There was a woman who'd been in the hospital 4 times. Couldn't get monoclonals. Then she got there, and they were looking at accepting her, and they're like, well, you're too far along. It's like, mother effer. You told me I couldn't go.
Where's my window? Where's my window?
Now you're telling me I'm too late. Like, I showed up to the party early, on time, and late. Yet I didn't get to go to the party because you said I couldn't go. And so now I'm going to go find ivermectin, keep me out of the hospital, and eventually I'll get sick enough that I have to come back in. And I don't even know. It's beyond reason. It's beyond logic that we have a state that criminalizes that. And technically it's not criminalization, but it's a threat of losing one's license, a medical license. That's not cheap, man. It's not the go down to DMV, pass a test, go take a written and a driving test and pay whatever it costs, $60 or whatever for a license.
No, you're talking about a lifetime of work.
Yeah.
Medical school, residency, practice, and now you can't do it.
Yep. And so that's why we fight for these doctors, because they're willing to stand up for what they believed and, conveniently what we believe to be right, right?
Yeah.
We probably wouldn't be, or we wouldn't be fighting the same fight for people over prescribing opioids or other. But, we're here to fight for these doctors who stood up and said there was reasonable treatment.
Right. Absolutely.
So,
not only that, the right for an individual doctor to treat an individual patient.
yeah.
This treatment by committee is insane to me.
Well, and it's like a Monday morning quarterback committee, right? It's a
absolutely.
committee that met virtually, mind you, to adopt a position statement that was adopted from the Federation of State Medical Boards. So they didn't even do their own homework. They went through, they said, well, we're members of the FSMB, the Federation of State Medical Boards. We like what they've done. We're going to utilize our position statement to adopt what they've done. And then we're going to do it under threat of loss of license. But we're not going to ever, quote unquote, enforce this. We're going to use the true enforcement mechanism, but we're going to use this to launch investigations, and we're going to write it into the statement charges. I mean, I got a lot of words coming to mind here, and not a single one of them I'm supposed to say. So it's insanity.
Absolutely. And for those of you that maybe aren't following along exactly, as clearly as I can state it, these are what death boards look like. This is socialized medicine come to pass in Washington. These are the people that would ultimately, if we were to let socialized medicine become a thing, ultimately decide whether you live or die when you go to a doctor. Because it's not the doctor that's going to tell you. It's that board who decides what the standard of care is. So have no mistake, that's where we're headed.
Well, and let's talk standard of care. So in the Turner case, we laid out the history of the COVID-19 standard of care. The legislature, so mind you, early 2020, the same board that we're suing, the Washington Medical Commission, came out with another similar statement. It wasn't a position statement. I can't remember what exactly it was called, but it was like a provider statement. And it said, these providers who are working, and these are my words here, these providers working under these current circumstances should not fear retribution from the board or board action. They should have the support of the board. And I almost quoted that part, word for word. That's 2020. Then you go to 2021. The legislature adopts a standard of care for proving that someone fell beneath the standard of care for COVID-19 treatment, and it uses a reasonable medical provider standard. Then these guys, 4 months after the legislature's adopted a true standard of care, come out, the medical commission comes out and it says, the standard of care is not this. It has no authority to override the legislature. It absolutely does not have that authority. So that's why these cases that we bring and suing these agencies are critical. I want to touch on one thing. We're utilizing the Administrative Procedures Act. We saw a huge win come out of the Fifth Circuit of the United States Courts of Appeal. Okay, so for anyone following, I know I've totally shifted subjects here. The United States Court of Appeals is the next level. Like, dude, this is like double, almost triple A. The next level up is the U.S. Supreme Court.
Right.
There are 11, and then there's a D.C., so there are 12, almost 13,
circuits.
Right? The Fifth Circuit on the pistol brace rule didn't rule on the merits of the claim. It didn't rule on the stability of the pistol brace. It didn't rule on the technology. It ruled in our favor, and this wasn't our case, I want to be clear about that, but our favor meaning those who are gun supporters. It ruled in the gun supporting individuals' favor on the Administrative Procedures Act in a 2-to-1 decision. So the pistol brace rule has been enjoined, at least temporarily, and the first note is we don't reach the merits on this, but we do believe that there's an adequate and accurate claim about the Administrative Procedures Act that this rule violated its adoption and implementation. It violated the Administrative Procedures Act. It is a very boring, rote, step-by-step type of law.
Mm-hmm.
It is extremely powerful. To me, if I want to go to a judge and say, you know what, I'm right here, if I can get a procedural flaw in the states or whoever I'm suing adoption of a rule or regulation, that's easier than saying, hey, pistol braces aren't going to result in more deaths. A
Right.
judge doesn't want to make that decision. A
Right.
judge wants to make the decision that either you followed the rules to make the rules or you didn't.
Now you made the statement that it's a very powerful way to win an argument, win a case, and we've been on basically on both sides of that, really. We've segued away from medical freedom into Second Amendment. So let's stay here for a minute and get some updates. We wanted to talk about how these judges that we're going in front of really don't want to rule on any of these cases. They don't want to rule on any merits. It's the rules of the rules that they want to talk about, that they feel comfortable making a decision on. In particular, we've got House Bill 1705. We want to update a little bit about that. Where is that? Where are we in the court with that? And what is the judge actually even sitting on right now?
Yeah, so right now we have appealed. So in the lower court, we brought that case in Stevens County. It was to seek an injunction or a stay or a stop of any enforcement of House Bill 1705 related to non-serialized firearms. And the judge there said, no, this case needs to go to Thurston County because you're suing a state actor, and under the revised code of Washington, venue or location needs to be where you're suing that state actor. Now, mind you, initially we pled this to sue Inslee and Ferguson and Sheriff Brad Menke, the sheriff of that county. But then we dropped and we changed it to the state of Washington because we don't believe that Inslee or Ferguson, I mean, certainly Inslee has no discretionary enforcement authority.
Right.
His job is to execute the law. Once it's done, he signed it. You know, I've said this several times. We didn't challenge that he signed it left-handed, right-handed, blue pen, right? Like, that's not our challenge. Our challenge is that it shouldn't be enforced at all. And so he's got no enforcement authority. Bob Ferguson arguably has some tangential, but usually that's only if somebody else fails to do their job. So if the county prosecutor in Stevens fails to do his job, then the AG can come in and start to prosecute these issues. So it's like an if-then scenario. And it's so far removed that it doesn't happen.
Right.
And so we argued and we decided that rather than in House Bill 1240, which got moved, the assault weapons ban, as they like to call it, which I don't call it that, but for ease, the 1240 case, that moved to Thurston County, and we're pursuing that on the merits, right? We're challenging that because we need to stop that law like now. House Bill 1705, we said, hey, look, we need to appeal these decisions to move everything where the state's involved to Thurston County, because otherwise you're going to end up suing the state on every invalid, unconstitutional act and end up in Thurston County. Several problems. One, it's going to cause a huge backlog in Thurston. Two, it's going to cause a backlog in the Court of Appeals there. And three, I don't elect a judge in Thurston County. I elect those in Benton and Franklin County, and I want my judges to hear my cases. When appropriate, obviously. And so, we appealed it. We filed our appeal, and today we got an answer from the state. Here's the state's approach to this. Talking about our lawsuit, they could have sued the sheriffs and prosecuting attorneys in each of Washington's 39 counties, along with every other chief municipal law enforcement officer and prosecuting attorney. They did not do that. So their argument is, well, rather than seeking a statewide injunction and suing the state of Washington or the AG or the executive of the state, Jay Inslee, as a figurehead, not suing him for what he's done, but suing him as the state of Washington, their claim is that, well, they could have gone all 39 counties.
Let's stop there for a second, because wasn't that their exact opposite argument in Grant County? That, well, we have to take it to Thurston because we don't want them suing us in every county in Washington.
Well, and that's the problem. And they claim we speak out of both sides of our mouths.
Wow.
But it's consistently, their defense here is, well, they should have just brought 39 lawsuits. You know what would have happened? We would have been consolidated into Thurston County.
Absolutely. We should send this to our friend Judge Hill in Grant County.
Yeah.
Remember the argument?
We should just put a bow on it and highlight that single sentence. But it's nuts. I mean, I've gone through this and highlighted it, but I think that to me is the most important part. that because we're seeking to declare a law invalid, they want us now to chase it in 39 counties to enjoin. If we want to enjoin it statewide, 39 actions.
Let's copy and paste. Let's do it.
Well, and that's a great question. That's should we just go ahead and do that for the next gun case, House Bill 1143, maybe permit to purchase. You know, if we're gonna go on that, maybe that's what we do. We fundraise the heck out of it. I mean, because it's going to cost us like $400 times 39, plus all the extra man hours, plus all the services, plus. Could you imagine whoever? So for people that don't follow this closely, the state no longer wants personal service, right? When you file a lawsuit, you have to serve it. Here, Rob, I'm suing you. Here you go, right? For you and I, there's personal service, but the state is now saying, and since the pandemic, and it's kind of nice, it's allowed us to be lazy and cheap.
Right.
It allows us to serve them via email. There's
Yeah.
a specific designated service box. And could you imagine if you're whoever it is, you know, assuming it's not, you know, AI, but a real person, if you're not whoever sits at that desk and sees these, like, who are these jokers suing us 39 times on the same issue? I'd be pissed.
Right. Oh, absolutely.
Be like, dude, this is frivolous.
Well,
In
then
fact,
we can just show them that.
well, and to your point, maybe we do that. Maybe we sue the next gun rights or any other statewide injunction. We sue and we bring it in all 39 counties and have the risk of the judges telling us, oh, hey, you know, you really should only sue in one county. But that's not the law. And the concern is, to your point, dude, they speak out of both sides of their mouths. We don't want to go to every county, but go ahead and sue us in all 39 counties. This is why we have people getting refunds for being drug felons.
Well, and let's be real. This isn't one assistant AG, and a different assistant. This is the exact same assistant AG that sat in Grant County, made that argument orally, is now making this in this response.
Yeah, I don't know that he's the one that signed off. He's certainly on the list. I mean, he's involved. There's no question. So to your point, it's not like this transferred from one division to a separate division. These are the same people involved. It's almost like, I don't know, they're sitting there off the wall and saying, well, what should we argue? Well, we argued this, but maybe it's better off to argue the opposite to prove this point. I mean, I'll just call it like I see it. There's no legal integrity.
There's no consistency.
Yeah, well, and they claim that we're doing the same,
right?
Mind you.
Right. Yeah, we're just frivolously wherever we want to be.
Yeah, and that we should have just, instead of, you know, that by changing it from Inslee and Ferguson to the state of Washington, and it's like we knew when we realized it, yeah, we don't want these. They have no enforcement authority.
Yeah.
To me, if I'm a judge, that would have been an easy dismissal. Mr. Serrano, why the heck are you suing the governor? He's not the legislature. Why are you suing the attorney general? He's not the legislature. You can go ahead and amend your complaint to the state of Washington. To me, that's what I would have done. But, you know, these judges just sent it to Thurston County to die.
Yeah, just send it over.
But we will fight, and it won't die.
Exactly.
I want to be clear about that. So
I mean, that's what we're seeing on the front, 2A front in Washington at the state level. What are we seeing at the federal level with our cases? What are the judges? What kind of games are they playing with us there?
Yeah, I mean, I've talked about our Hanford case, and to start off, Senate Bill 5078, which was a 10-round magazine. That one's still sitting there.
Yeah,
it's
just sitting there.
Talk about a slow death. Like it's just sitting bleeding. I saw that the interveners, which is quote unquote Alliance for Gun Responsibility, and I don't like saying that mouthful because it's not that. It's a leftist propaganda team.
It's Alliance for Getting Rid of All Guns.
Right.
Operation Zero Guns is, I think that's like word for word from their website. Zero Guns.
Maybe that's what we should call them. AOG or. Yeah, Operation Zero Guns is they filed something, some Connecticut case that they believe brings back to what Judge Dimke should be doing. And I saw that come across my desk yesterday or the day before, and like, oh sweet, maybe Dimke's actually doing something now. She's still sitting on it.
So timeline reminder: we were in court in Yakima the day before Thanksgiving, 2022.
Yes.
We're now in the first week of August, 2023.
Yeah, with a Christmas present that was supposed to come.
Zero bupkis from the judge.
Yeah, and I've said this all along. I'm happy to get to the Ninth Circuit as quickly as possible. I think we have a solid record in that case. I think maybe she's doing us a favor, and we should really just hone in on discovery and let people object. Let Alliance for Gun Responsibility object. Let the state object. At least it would show that there's like a still live controversy, aside from the live controversy that people are prohibited from selling these magazines in the state of Washington.
Well, let's dig into a little bit the discovery aspect of it. What would we request in our discovery?
Oh, there's first we have a Public Records Act request out on Jay Inslee's, on Bob Ferguson, the Attorney General's sweep, and he used that term, sweep of gun vendors who were selling these on, when they were prohibited, right? Greater than 10 round magazines. That Public Records Act request, I think I've received 5 thumb drives. Most are not helpful. Some are his pressers. Some are drafts of his pressers. It's always interesting to see how the verbiage changes. But there's really nothing actionable on that. A lot of it was the pleadings in the federal way discount gun case, which we were involved in early on and are no longer involved in, where, the individuals involved there, it was that they had sold some of these magazines when they were prohibited. And so I'd like to know more. I'd like to know if the Public Records Act requests that the information we're being provided is accurate. If it's not, we'll sue them on the violation of the PRA, the Public Records Act, which would be great because then we could get attorney's fees and fund another attorney. I would like to know, what information, because my recollection on 5078 is that Inslee and Ferguson both testified, or excuse me, Inslee and Ferguson's first assistant attorney general, Kristen Boneski, I think is her name, testified on behalf of the bill. So I'd like to know what correspondence occurred between the legislature and the AGO, the Attorney General's office, because guess what? That's not a privileged communication. They're not their client.
Right.
I'd like to know what other information was going outside. Specifically, I'd really like to dig into Alliance for, termination of gun ownership, whatever we want to call them, ATR, AOC, right? We'll find one that fits that bill. But I would really love to dig into what they were doing, because they claim standing based on the fact that they lobbied this.
Right.
I think we need to put those people, and we have
How much
continually
lobby?
put. What's that?
Well, to find out how much lobbying they actually did.
Yeah.
Well, and I've told you this, and let's just name them on every lawsuit we have going forward with 2A.
Yep. I mean, if they're going to intervene, let's just make them defendants.
Yeah. Let's start pulling money out of their pocket.
Get them dismissed, and then have them force their way back into the case.
Could you imagine their fight to not be named?
Dismiss us, but let us intervene. We don't like the defendant status. We just like the intervener status.
Oh, geez.
I could see him doing that, though.
Absolutely.
I mean,
our good friend, Mr. Bakalis.
Yeah. These people don't care about our rights. They care about winning.
No, absolutely.
Al Davis, just win, baby.
Just win. And they don't, the consequences just don't even come across them.
Back to your, how do you engage people? The consequences will matter when these people need a greater than 10 round magazine or a so-called assault weapon to defend themselves, or their mother or their grandmother is mugged in broad daylight.
Right.
Or they themselves have some sort of walking out of a Mariners game incident where they're mugged.
Or heaven forbid, there's some sort of foreign invasion, or the government no longer is on their side.
Yeah. And at that point, well, if the government's not on their side, the government will actually protect them. Right? Let's be clear about that.
Well,
it's the government that's on their side that they need to worry about.
Yeah.
Maybe they're turncoats and they Benedict Arnold it. I don't know. But
what's when it's when the government finally decides that,
we'll step on them too.
You're the group that we don't really care about anymore.
Yeah, absolutely. And so I would love to get discovery on those interactions. That would be extremely beneficial. I'd like to get discovery on, how much money was spent to work with California and other states. So that case could lead to great discovery there. Yeah, I mean, so that's that case. We've talked about 1705. I think I've touched on 1240 and its status that, we're going to tee up a motion here in short order. And because the docket's filling up, I'm not going to say specifically when. Not that, I mean, I know I sound like some conspiracy theorist, but like, we're targeting it soon and I don't want to lose that slot.
Right. Right. Well, we've updated on what we've got currently going on. What do you see in the pipeline for us coming up?
Yeah, I mean, I mentioned this early on. We're going to have a hearing in 2 weeks, less than 2 weeks, on Turner v. WMC, Turner versus Washington Medical Commission. And that's squarely about whether the Administrative Procedures Act is on our side and if rulemaking was invalid. We've got some work we're doing on behalf of Scott Miller to appeal his decision. I mean, people have probably forgotten about him. Obviously, we haven't. But he's a physician's assistant down in Washougal, Camas, Vancouver area. And he got hammered really hard by the Washington Medical Commission for his decision to prescribe ivermectin and speak out on its behalf. A year ago, I think, is when he got his punishment. And so we've been talking about appealing it. And Karen and I were working today and earlier this week to really get it filed and have that heard hopefully in September. In addition to license, as well as Dr. Lynn's license, the work that's going to go on there. We've got some scheduling conferences heading up that will tell us when their hearings are if we don't stick the landing in the Turner versus Medical Commission case. We also have Dr. Wilkinson. We're waiting on his what the formal findings are in his case and whether or not that needs to be appealed. So we've got a lot of stuff going on. We've kicked around some of the other cases to whether or not we're going to appeal them. We haven't decided 100% on a couple of those appellate cases. We're looking very closely. Kind of really what led us into this discussion earlier was your question of gamesmanship that we may be seeing in opinions. When we look at the Wilkinson versus Rogers, which was a lawsuit on the Medical Commission's position statement in front of Judge Rice in Eastern District of Washington, we amended that complaint basically. I don't want to say it at his advice because he denied our temporary restraining order and gave us kind of what we thought was the roadmap of what he wanted to see and what he was not willing to hear. So we pulled all these complaints out and tweaked it. And now we look at it and it's like, well, gee, we really planned on appealing that. But the way we modified our complaint, it doesn't lend itself to a good appealable error. So it's like maybe we should have just stuck with it in the original course, allowed for an appealable error, and planned the appeal. Unfortunately, the way it sits, the way we amended that complaint based on his early ruling, we tweaked it and
Took the teeth out of it.
It did in a lot of ways. I mean, there was still merit to the argument. I would never say it was frivolous or unwise to pursue it, but it took a lot of the teeth out of the appeal. Right. Not the substance of the case. And I want to be clear on that. It took the teeth out of the appeal, not the substance of the case. So, right. And we have a couple of decisions from him that did that. And so, is he looking down the road when we file our stuff and saying, how could I whittle this? Maybe, maybe not. But it's happened twice.
Yeah, there's definitely a pattern there. When we're learning, right?
We are.
Learning process. We're figuring out. We've got opponents. And unfortunately, it's not just the opposing counsel.
Yeah. Absolutely, and we just need to be on our toes for every one of them.
Yeah. Very good. Well, we're at the hour 15 minutes. So we've been talking for quite a while. Is there anything else that you wanted to update our followers or listeners about what we got going on? Anything to be aware of coming down through the legislature or looking forward toward 2024?
Yeah, I mean, your question the other day, we were talking about House Bill 5469, 5489. It was one of the other trans kids bill, right?
Yeah.
And I think it was exactly the same as House Bill 1469, but the Senate's version. And I'm going to just kind of caveat it with I skinned it. I didn't read it. To the extent there are any differences, that bill will be right up. I mean, it's going to be the same thing, just hammer home these trans kids things.
It's in queue.
And it also addressed foreign subpoenas, meaning if a state subpoenas medical records, that those subpoenas are supposed to be, the word's quashed, but destroyed, ignored, however you want to term that, which is hugely problematic. If I live in Texas and I'm a parent, I think my kid gets gender care. I hate to call it that. My kid gets transmorphed here, and I want to know what doctor, like I find out the doctor who did it, and I subpoena the court in that county to give me those records. By law, the court cannot do that. That was under 1469, but it's also in this other Senate bill.
So they're just trying to doubling up on that. So let's talk a little bit about that, because there's actual cases where one parent has gotten their parental rights and traveled to a different state, and under those state laws were able to, or are in the process of, changing the gender of their kid, while the other parent was in opposition to that. So I mean, that's just one scenario where there's obvious issues that are going on there. Not to mention just the obvious issue that the kid is undergoing something that he can't consent to, right? The parents are making that decision for them. But obviously that one parent's rights to that kid and their well-being completely being ignored in that instance. But another thing occurred to me, especially with Sound of Freedom being top of mind for a lot of us. These bills also allow for abortion care, and the exact same rules apply to abortion care. So if a trafficker who has possession of your kid brings them, or any kid brings them into Washington and demands and wants abortion care, they can do that. And there's no way for you as a parent or any party that's interested in the well-being of that child knowing what kind of care they got or what they had. And so we're really opening that avenue for that to happen, not only for, you can call it transgender vacationing into Washington, you can also call it abortion care for traffickers into Washington. We're inviting that into our state. We're inviting that kind of criminality element into our state, and not just criminal, it's evil, just as a base. And that's what these legislators think is important.
Yeah, I mean, Mark Elias this is like his hill to die on. Bob Ferguson is very proud of the work he does to defend that right. Now, of course, he sells it as though he only cares about the single moms that may not have other options, and that might be the best financial choice for them, or the rare case of rape or something of that nature. But to your point, that man allows this evil and proudly defends that right. And I'm sure if you called him out on it, he would say exactly what I just said. Well, there are people that need it. Well,
yeah, well, there are people that need it, but why are we? I mean, what's crazy about it to me is that they're specifically protecting somebody that does this to a child.
Yeah,
they're not protecting that child's rights, which is what these should be doing. They should be protecting the child, and what Idaho is attempting to do, and our great AG is trying to fight that.
Yep,
it absolutely blows my mind. Under the guise of what they call women's rights.
Yeah, they've perverted the circumstances. There's no question about that.
So, I mean, we're talking about it. We see it as an issue. What path forward do you think we have to oppose this? Is there a path that's obvious? Is there something we're waiting for, looking for?
Well, there are some great parental rights cases. In fact, one of the U.S. Supreme Court cases came out of Washington 20 or 30 years ago. And we're looking at how that aligns with some of these bills. I personally, and I think I've mentioned it on the podcast, I know I certainly have talked to you about it, these out-of-state subpoenas, I absolutely think, and if for whatever reason any of these individuals is listening, the attorney generals of Montana, Idaho, and Utah in particular should be keying in on these, and it should be a state versus state lawsuit. Why? Because the U.S. Supreme Court is going to care about that case, not because they're I mean, they're certainly well better funded than we are, but I absolutely believe that those three states should align themselves and sue the state of Washington for House Bill 1469 and its limitations on obtaining records through a lawful process, a subpoena issued to a court and through a court lawfully by a resident of another state or a government of another state to determine whether or not its laws are being violated. They have absolute standing, absolute right. And I mean, we've reached out to some of those folks, some of those attorney generals. So if anyone's listening and they have a direct contact to the attorney general of Montana, Idaho, or Utah, please reach out to them and have them reach out to us. We've got a very quick, succinct email talking about why those states should care about these laws and why they should sue the state of Washington. And again, I think more importantly, if they do it rather than us, not to take the burden off us, but more importantly, it ends up in the for us, it's going to have to wind through the courts. I think they have ways to expedite those appeals as a state versus state.
Yeah, well, we know just how good they are at stretching things out, and a lot of times all they got to do to beat us is just make it so long.
Yeah,
we don't have the resources or the time.
Yeah, either that or they bury us in the paper. I mean, we have 3 attorneys working here.
Yeah.
Each one of those attorney general's office, even the lightly staffed Montana one, has more than 3. I can promise you that.
Yeah.
So there's a lot to be done. Ways to approach it. Again, we're going to look at some of these other bills from the parental rights and really try to hone in on how do we get there. I mean, we understand it. We understand the pain that everybody else is experiencing. We're not immune from these poorly developed laws. That's why we fight them. And we understand the importance of fighting for our kids, and we're going to do that.
Yeah, and if there's one takeaway from this podcast, I hope that everyone understands that it's at levels that we have to fight it. It's at the ballot. It's getting educated. It's talking to your legislators. It's going to your public meetings and letting them know what your opinion is. And anybody and everybody is qualified to do it. So don't ever feel like you're not capable or qualified to speak up. You know, all you need is a very simple and succinct statement of your opposition and your reason why, and that's good enough to let those people that are decision makers in your life know that, hey, people are paying attention. People do care. It's not just it's not just a flip of the coin. The community actually doesn't want this to happen, or does want this to happen, if it's a good thing. So that's definitely what I took away from this, and what I'll be preaching to my friends and fellow fathers out there that really need to start getting engaged and active and understanding that their family that they're working so hard for, maybe working overtime for, is at risk in other ways and in other spheres than just financially and taking care of their roof over their head and their food. That maybe some of that extra overtime maybe needs to go towards policy that's going towards their kids.
Absolutely. I mean, you wrapped it up perfectly with the bow on it. Everyone has their role to play, and no matter how unprepared you may feel, or look, we didn't set out to start a nonprofit organization. We set out to do what was right, and this is what God told us to do. And God is talking to each one of us every day, giving us some sort of, nudge to do the right thing. And I can't tell you what your right thing is, and you can't tell me what my right thing is. Silent Majority Foundation is my right thing. It's your right thing because we're here. There are other people that have great talents, great skills, and even if you feel untalented and unskilled, God will take that rock and turn it into a marble statue. So, be prayerful and be willing to act. And once you have those two things together, you can play your part. And if you're not a person of faith, then just act.
Amen. I am a person of faith, so I'll end that with an amen. I agree with everything you said. Thanks for talking, Pete. This was awesome. Thanks if you stuck around for the entire conversation. God bless you. We can ramble on. Pete's a great talker. He's a lawyer, so he comes by it naturally. But thanks for listening. We're going to try and do this, like we said, every Friday in the afternoon between 3 and 5. So be looking for it. And thanks for listening, and we'll see you next time.